Hi, welcome back. We are now beginning to delve a little deeper into our course on securities regulation, and I'd like to take this opportunity to talk about directors. Directors who are responsible for the day to day management of the company. But before we get into the idea of directors, I'd like to put forth a theory that has been subscribed to by many scholars across the world, that of it's an economic theory, that of agency problems. Now, we've talked about agency problems before. When you hand over a good or a product to a delivery person, you are creating a contract of agency. You are giving that delivery boy something valuable to carry. You've just carried out a contract of bailment as well, because the delivery boy is supposed to take care of that good as if it were his own. Similarly, we create a number of agency contracts within the realm of company law. There are three agency contracts that are primarily created. The first agency contract is between shareholders and directors. Now, shareholders put in money into a company and then they expect the directors to run the company and bring them profits or dividends. In other words, directors are responsible for the valuable assets or the money that has been provided by the shareholders into the company. As a result, directors are administrators of the company, but they are also trustees for the investment made by shareholders. There are two other agency contracts or agency problems that come up in company law. The second one is that of the company and a lender. A lender also lends money to a company, expecting that the company will return that money with interest, will use that money to grow in terms of profits and then pay back the principal amount in lent along with the interest. If the company doesn't, well, the agency contract falls apart. The third, and in India's context, I believe, the most important agency contract or agency problem that is created is between minority and majority shareholders. Consider this: a public listed company which is promoter driven, and retail shareholders or common shareholders like you and me who are investing on the stock market. We are investing thinking that the leadership of this company, the promoters, the directors, they will use the money that we are investing, whether through an IPO or through the secondary market, to the best of their abilities. Now, if there are problems where, let's say, the majority shareholder directs the directors to do something that is not in the best interest of the company, then again, the minority shareholders lose out. So this is the third agency problem between majority and minority shareholders. Now, how do we resolve these issues? How do we address these three agency problems? Well, it turns out that you have already learned how to deal with these problems. The first agency problem, that of between directors and the shareholders, this agency problem is solved by the entire gamut of corporate governance norms. The second agency problem, which is between lenders and the company, is solved by the insolvency and bankruptcy code, where if a company does not return money to a lender, the lender can take you to the NCLT and say insolvent. The third agency problem, that of between majority and minority shareholders, that is solved using oppression and mismanagement provisions, as well as section 245, which is the class action suit provision. Moving ahead, I'd like to talk a little bit about how directors ought to behave and what is the role of independent directors in listed companies. Again, these are things that you should have been taught in company law. However, it's just good to refresh our memory once again. Now, we know that directors are required to act in the best interests of the company. We've seen how so many of the powers and duties of the directors do not allow them to make a personal profit out of the affairs of the company. They cannot take away company assets or properties as if they were their own, and they must work towards making the company more profitable. And this has been the case mostly. However, in India and many other developing countries, the idea of a separate board of directors and shareholders, that idea seems to have been blurred a little bit. In India, what we have is something called concentrated shareholding. What this means is that the shareholding of most companies is concentrated in the hands of a few shareholders. We call them majority shareholders or promoters. So, in other words, it's not unusual to have a single individual or a family, in India's case, having immense control and ownership and therefore authority over a company. Now, think of any large company that exists in India, whether it is Reliance or Godrej or Jindal or Tata. All of these companies have very strong authoritarian figures as promoters. And it is not unusual for the company to follow whatever orders the promoter, as in the shareholder, is giving the company. In other words, the control over the board of directors is heavily in favor of the promoters themselves. What this means is that even if the directors as individuals believe that a particular decision will be bad for the company, they'll still have to go ahead with it because the promoter said so. Now, this creates a very curious case of an agency problem. We've discussed previously that one major agency problem is between shareholders and directors. But if the majority shareholders and the directors are more or less the same person, the first agency problem typically does not exist in India, where directors follow the line that has been told by the promoter and they can't really say no. We've seen this happen in countless situations. For example, in the case of Satyam, Ramalinga Raju and his brother were promoters of Satyam. And even though there were directors on the board of Satyam who would have thought that doing accounting fraud is not a good idea, even if they were independent directors, they were still appointed by these promoters. And therefore, they kind of went along with the ride. Now, this incident, the Satyam incident, brought into sharp focus the independence of independent directors. And we began to ask that question, are independent directors truly independent? Now, post Satyam, of course, we've brought in a lot more stringent provisions into the Companies Act as to who can and cannot be an independent director. Now, we know for a fact that independent directors cannot be related to the promoter or the shareholders, cannot be an employee or a past employee, cannot have been an advisor even to the company, and can only own up to a certain extent of shares in the company. However, our Indian companies and promoters seem to be very, very creative when it comes to making independent directors or appointing independent directors. For example, it is said that the independent directors of Satyam, at the time the scandal hit the roof, were alumni of the same university as Ramalinga Raju and his brother, Andhra University. So as a result, we see that the independence of independent directors may not be as true as originally believed. Therefore, by inculcating the corporate governance norms that actually have been transplanted, not within India, but from outside of India. So effectively, India's corporate governance norms are nothing but a transplant of Sarbanes-Oxley Act, which is in the United States, and based in the Cadbury Committee report, which is from the United Kingdom. And what we've done in India in terms of our corporate governance norms is that we've simply copy-pasted those provisions of law into the Indian Companies Act. But in the United States and in the United Kingdom, you would have a dispersed shareholding, not a concentrated one. As a result, when we were transplanting these corporate governance norms, we were effectively trying to solve a problem that didn't exist. There was no agency problem between shareholders and directors in India because shareholders and directors in India are pretty much one and the same. Instead, the problem that we should have been trying to solve is the third agency problem, which is between majority and minority shareholders. I wanted to bring this up because the vast majority of the law that SEBI has given us in terms of public capital markets seeks to do away with this problem, seeks to provide more power, more protection to minority shareholders in the public markets than majority shareholders. This concludes our entire review of company law along with a small snippet on directors. We'll now be pushing forward into what SEBI does and where does SEBI play a role in the lifetime of a company.